Hi, everyone. Thank you for joining us today as a continuation of our virtual client seminar. I'm sorry we were starting a few minutes late. We were having some technical difficulties over here, but I think we got it figured out. So it looks like we have 122. Oh, it's going up. Okay, so several people joining. We appreciate you guys coming. Today, as you can see, I'm sharing my screen with you. So we're going to talk about the impact of social justice movements in the workplace. I don't know how many of you watched the presidential debate last night, but I'm sure that that is being discussed in your offices right now by your employees, by everybody. And we kind of want to go over how to handle these situations, especially now where it's very contentious. It's causing a lot of tension among different people with any realm of politics. It comes with some differences of opinion, and we need to know how are we going to handle that in the workplace when issues arise. Okay, so let's get this started. This is our traditional disclosure. This should not be a substitute for specific legal advice, especially on this topic, because everything is going to be addressed on a case-by-case basis. No one size fits all here with how to treat employees or situations that come up in this particular topic. Okay, so first, we're going to go over the kind of various social justice movements that are prevalent right now. I probably did not end up including all of them. There are probably more. I could probably create a list that was much longer than that, but within the time that we have, I'm going to focus on what I think are the biggest issues right now. And then we're going to talk about the ability to regulate speech in the workplace and how that interacts with traditional employment laws. And then finally, we're going to discuss off-duty conduct and what an employer can do to regulate that for their employees. Okay, so social justice movements. I think that this is probably a relatively new term, even though it's not a new concept. We hear a lot of it in the last couple of years, and this phrase is just popping up everywhere from news articles, social media, everywhere that you see it, you hear about social justice movements. So these are kind of the widespread social and political topics that I think are most at the forefront of everybody's minds, especially minds and in the media as well. And we still have some Me Too movement, even though that one started several years ago. It's still very prevalent today. And then we've added to that Black Lives Matter, Blue Lives Matter. There are constantly things in the media about cultural appropriation issues. One thing that immediately pops to mind is, renaming professional sports leagues into a more modern name rather than something that hinges on a particular culture. And then we also recently had some expansion of Title VII of the Civil Rights Act to specifically include sexual orientation. Then we have OK Boomer, which I don't know how many people are aware of that one, but it's kind of a phrase that comes up. I even saw some last night when I was scrolling through social media to see kind of how people were reacting to the debate, and you would get somebody from an older generation talk about, their support or not of a particular issue or candidate, and the response would be something like "Okay, Boomer," and that's kind of a phrase that's commonly used among different generations when they disagree with the statements of the other. And then, of course, we have pro-life and pro-choice issues that come up around every single election cycle, which is particularly prevalent today because there's a Supreme Court justice opening. And for many people who fills that position is going to be very important because they think that it has a huge impact on pro-life and pro-choice issues. Okay, so how might Okay, somebody asked a question. It says, will we receive a copy of these slides? Yes, you will. They will go out tomorrow. So everybody will receive a copy of the slides, so you don't have to worry about taking super copious notes at the moment, because you will get a copy of them. I have the wonderful Stephanie here with me helping me navigate through this, so I need to ask her a question. How do I get rid of this pop-up box? Just minimize it. Okay, sorry. Okay, so what types of employee involvement are likely to come about in response to some of these social or political issues that are just right at the forefront of everybody's minds right now? So you're going to have a lot of verbal advocacy, and that could, or opposition. So that could just be employees talking amongst one another. It could be employees talking to their friends. It could be in the workplace, outside the workplace, whatever the case may be. People are talking about this. I even made a phone call to some business the other day, and I was placed on hold, but they didn't put it on hold. They just like set the phone down, and I could hear people in the background talking about how filling the Supreme Court justice seat was going to affect their daily lives. So I definitely think that a lot of people are discussing it in a lot of different places. You also have written advocacy or opposition. That could be anything from posting on social media to wearing clothing that supports a particular cause or candidate. We've had a lot of clients call recently about employees wanting to wear specific masks that advance their causes. So that could be a form of written advocacy or opposition. And then you have, taking it a step further, there are numerous protests going on across the country and even here in Oklahoma. So chances are at least some of your employees have participated in those activities when they're not at work. And then just general discussions about current events. So it may not be in specific categories of a specific social justice movement, but they're definitely talking about current events. They're talking about the election. They're talking about how these things are going to play out in the future, whether they support them or disagree with them. So I think that at least at this point, there are a lot of these things that are coming up in everybody's workplaces. And do what?
So just put it on the screen and select the arrow to the right.
Oh, gotcha. Sorry about that. My slides were not advancing. Okay, so always with politics, there's always been a difference of opinion. With every single different movement that there is out there, you're going to have people on one side of a line and people on the other side of the same line. So how, as an employer, should you treat that, or should you get involved at all? Because many of these issues are at the forefront, you're going to have situations where even if your supervisors aren't engaged in these types of discussions, they're probably going to be in a position where they can hear it. They can see the employees interacting, and those employees aren't always going to fall on the same side of an issue. So it's important for you to know your options when addressing these issues and to recognize that tensions can arise. I will say that most employers that I have talked to lately don't kind of take an approach where they're not going to address it unless it becomes a problem. And that makes sense in a lot of different ways because, like I said, this has been going on for much longer than any of us have been in the workforce. It's just when there are politics involved, there are also differences of opinion. So it's generally not something that you have to address unless it becomes a problem, especially because it's been being discussed no matter what. So the important thing is to recognize when it becomes an issue and to address it appropriately. And to ensure that what some people might call a difference of opinion, the person on the other side of that opinion might interpret that as creating a hostile work environment or as some evidence of discriminatory animus in that regard. And you want to make sure that you are not walking on that line and that you are allowing employees to have civil discussions, but not creating a situation where employees are uncomfortable at work. Okay, so that brings us to the ability to regulate speech. And I don't know if you guys follow. I just love to read the comments when I see them on social media pages. It's a habit of mine. I'll read through 100 comments just to see what kind of things people are saying. And you will see all the time somebody saying, my employer told me that I got punished for saying this thing, but I have First Amendment rights. Well, what a lot of people are not aware of is that there's really no First Amendment protection in private workplaces. Now, public employers, if you work for a government entity, they certainly have a lot more limitations on what they can and cannot do with their employees and limiting their speech. But as far as private employers go, there are a lot of employers are granted a lot more leeway in what's allowed in their specific workplace. Now, that being said, that is not a rule that will apply all the time. There are exceptions, as there are with every single law, and this is no exception to that, because there are, of course, exceptions. One of the primary exceptions here will be the National Labor Relations Act. In years past, it was understood that the National Labor Relations Act applied to unions and union activities, but in more recent times, they have certainly tried to expand their grip into different employers, and it now applies to all employers, private and public. Now, that doesn't mean that in all situations you're not going to be able to regulate the type of conduct that's happening in your workplace. Of course, you certainly can do that in most instances. But the National Labor Relations Act, which is enforced by the National Labor Relations Board, and I'll probably just say NLRA or NLRB from now on, because that's a mouthful to say over and over again. But the NLRA protects certain concerted activity by employees relating to the terms and conditions of employment. And there are a number of different tests on whether or not something's actually concerted activity or whether it's an employee acting on their own, because concerted by its very term indicates that employees are getting together and advocating for specific terms and conditions of their employment and trying to make a better workplace or a work environment for themselves. So I'm not going to get into all of that. It gets confusing. And quite honestly, the NLRA, the text of the NLRA hasn't really changed very much, but its interpretations basically change every election cycle depending on who is in office. So for example, when the Obama administration was in the White House, there were a lot of restrictive rulings that came down on employers. That basically said if you had a policy, whether written, verbal, or just a practice, that an employee could reasonably interpret to mean that they were not allowed to talk about their terms and conditions of employment, then that was going to be unlawful. But the Trump administration has kind of dialed that back. So those are still in place, but the enforcement mechanism and the interpretation of those things has pulled back a little bit since the Trump administration took over the White House. Okay. Also, people tend to think of the NLRA as union activity only, and so they think, well, I don't have a union in my workplace, so this doesn't apply to me, but it actually does. So I am going to go over these situations where you may be prohibited from restricting employee speech. So as I said a minute ago, employees have the right to engage in concerted activities for collective bargaining purposes, and they also have the right to engage in speech and conduct when it concerns the terms and conditions of employment. Now that's a very broad term, right? Concerns the terms and conditions of employment. That could be anything. That could be we want more air conditioning and it's really hot in here. That's a term that could potentially be a term and condition of employment. But it's also important to recognize that this is going to be a case-by-case basis. So don't take any specific example I give here and say, oh, well, I'm good because Melissa's slideshow gave that as an example. These are very fact-specific inquiries. There are a lot of defenses available to employers. There are a lot of things that we would want to know before we gave any specific advice on what your employees are doing, because otherwise you could go astray. You could end up inadvertently violating the NLRA, and we certainly don't want to end you or to put you in hot water because of that. So Whether speech is protected or not in the workplace can depend on where and when it occurs. So, for example, the first example there, employees may discuss political issues relating to working conditions and pay during regular work hours. So we know that they can certainly talk about that, but when and where it occurs can be, an issue that depends on whether or not it's protected. So if they are discussing those things, you don't have to allow them to, if they're bank tellers and they're waiting on customers, you can certainly prohibit them from doing it while they're on the clock and waiting on customers and they're trying to talk about these things. No, we can certainly make them talk about it on their meal or break times and not while they're actually performing the functions that they were hired to do by your company. So the where and when is important in that context. And then for the second example there, employees may participate in a protest when off duty, but if they call in sick to participate and that's a violation of your policy, then they would be subject to discipline. So, for example, even from a public relations standpoint, you may not want to prohibit your employees from engaging in social justice activities or political activities that they are interested in and for which they support. But if your policies in place say, hey, sick leave is for when you are sick only, and then you find out that an employee called in sick and tried to use sick time for a time when they were not sick, then that again is going to be a where and when situation where otherwise potentially protected conduct could be in violation of your policies and which you would be within your rights to act upon. Again, we have some more protected versus unprotected political speech. This can get tricky because to some people, an issue about a particular candidate or a platform or an issue that's come up might just be a difference of opinion, but for somebody else, that might be what they consider to be something discriminatory or something that has some sort of an animus that might be unlawful in a workplace setting. Now, that's not going to be necessarily be the case, but again, that's why we have to address it on a case-by-case basis. So if participation in politics or public advocacy concerns the employee's terms and conditions of employment, it may be protected and the employer may not be able to prohibit it. So, for example, we will be better off if President X takes office or remains in office or whatever the case may be, because the minimum wage will increase. So the kicker there and the important part is the minimum wage will increase. Employees discussing wages is one of the primary topics of the NLRA, and it is considered kind of the quintessential term and condition of employment. So how much we're being paid and why. And this can touch on a number of different areas that are somewhat related. So maybe pay, I'm discussing wages, but it's also related to gender. And are we applying it to equally across the board? Is everybody in a like position receiving similar pay? And if not, is there a legitimate reason why that's happening? So that's kind of the quintessential issue that comes up. And that is going to be one that I feel pretty confident saying if your employees are discussing wages and trying to advocate for better work situations, that's going to be one of those topics that the NLRA certainly takes a pretty strong stance on. But on the other hand, if political speech creates a discriminatory or hostile work environment, it is not protected. And so if you have employees engaging in that speech that would potentially create a discriminatory or hostile work environment, then you certainly can regulate it and prohibit or discipline an employee for doing that. So commonly you would see if political speech in any way touches on protected categories such as race, national origin, sex, sexual orientation, as of recently, religion, etc. So if those topics are touched on and kind of touted as political speech, we can't necessarily just say, well, it's political speech, so I'm not going to do anything about it, because if it otherwise violates your policies, we're going to take the political part out of it and determine whether or not the words that were said, the actions that were taken would otherwise violate the policies in your handbook that you have for anti-discrimination, anti-harassment, anti-retaliation, those things. So we're going to just take the political aspect out and see what the root of that issue is. Again, clothing and written speech has become a very big deal. A lot of employers are asking these questions. And again, where I've seen it most is employees want to wear a specific mask that either supports their cause or opposes another cause. In fact, I just saw a news article or a social media post the other day where an employee alleged, and they were interviewed by the news station, that she was fired from her job for wearing a Black Lives Matter mask. And, the way that the news media portrayed it is she's wearing this Black Lives Matter mask, and she's trying to advance that in the workplace, and she was fired for that. Now, there is almost always, and I would venture to say in this situation, there's another side to that. That's probably not the whole story. Now, maybe she was fired for wearing a specific mask, but maybe the employer had a rule in place that said, you know what, we're only going to wear blank masks because I don't want there to be issues between my employees where wearing a mask actually becomes the source of tension because some employees interpret that as against their beliefs, or it causes too much friction or tension or arguments in the workplace. So we're just going to do plain masks. It could have been something like that. I obviously don't have any inside information about that, but there's typically another side to that story. And that's what we're seeing a lot of. So you as the employer will have to decide how you want to handle that if and when it becomes an issue in your workplace. And sometimes, again, the response is, you know what, we're just not going to do any written speech on clothing. We're not going to allow people to wear t-shirts supporting their candidate. You can do that on your own time, but not here at work. And that's just going to be up to you. And it's going to be dependent on what's going on in your workplace, how the employees are handling it, whether or not it's become a problem, if it's interfering with employees' ability to work. These are all considerations that you're going to make before you decide how you're going to treat it in this situation. And, honestly, employee response and employees asking for specific things might end up driving your decision making, but you just want to make sure that nobody's being marginalized or treated any differently in how that issue ultimately plays out. Which actually brings us to our next slide, how to handle issues with political speech. So, went too fast. Oh, there it goes. Okay. So again, case-by-case basis. Check your employee handbook. Now is a great time to do that, to see if revisions are necessary. Do you have policies that relate to off-duty conduct? Do you have policies that relate to social media use? Do you have policies that make sure that employees know what discriminatory, harassing, or retaliatory conduct looks like? Those are also really good discussions to have with your supervisors to let them know, hey, you need to be on the lookout for these issues as they come up, or at the very least, don't participate in them. I think that most of you have probably been to our seminars enough to know that if a supervisor engages in conduct as opposed to just two equal employees who are on the same level, if a supervisor actually engages in conduct, it's a little bit more stringent of a standard for the employer if it results in a lawsuit. So you certainly want to make sure that your supervisors are acting the way that they are supposed to and looking out for these issues, and certainly not engaging in any conduct that could be considered discriminatory, harassing, retaliatory, etc. So, okay, we've got another question. Let me see. So I got a question that says, do you have an example of these policies you can share? So we typically have kind of a base policy that we use for certain of these issues that come up, and it's part of our kind of basic employee handbook, but we don't have any pre-finished policies that we just give to all employers, because all employee handbooks and all policies should really be tailored to the specific business. So the policies that I would recommend for one company, I wouldn't necessarily recommend for another. So while we do have policies and we are certainly happy to provide those, we do typically tailor those to the specific business to make sure that they are, that we're not giving you a policy that doesn't actually work for your company. It said somebody raised a hand. What does that mean? What? Oh, okay. Okay. Perfect. Okay. So as you're looking through your policies, you certainly want to look at your handbook and make sure that you have the policies that are in place to protect you. And that's not just for political speech, mind you. Everybody should have an employee handbook or at least policies in place that relate to discrimination, harassment, and actually harassment is just a form of discrimination, but so it's not necessary to distinguish them, but employees often distinguish them. So that's why I'm saying it that way. But discrimination, harassment, retaliation, you want to make sure that you have policies in place, even if you don't have an overall handbook, because one of the defenses available to you as an employer, if you get a lawsuit filed or an administrative charge filed against you, one of the defenses that we can put forward on your behalf is the fact that we had policies in place to address these. And then we can sometimes say, you know, we had a reporting mechanism in place. We prohibited this conduct. We told the employee in our policy how they could report these issues so that we could address and fix them, and they didn't follow that. They basically failed to take advantage of the measures we had in place to prevent and correct these issues, and that can be a complete defense to liability. So if you don't have these policies, it's not just important for political speech, it is important for the defense of any lawsuit or administrative charge that comes up. So, you know, this is a reminder that it's a good time to look at it, but you should have it anyway, regardless of whether political speech is an issue in your workplace. Okay, I got another question. This presentation is recorded. Will we receive recording as well as PowerPoint? Stephanie says yes. She's the girl with the answers. So she says, yes, you will receive the recording and the slides, and both of those will go out tomorrow? Yeah, both of those will go out tomorrow. Okay, so as you're looking at those policies, if you haven't had your handbook looked at in a long time, you might want to have somebody look at it because, again, the interpretations from the NLRB on the NLRA and other various things can change as laws are updated, as decisions are handed down. So you certainly don't want to be operating probably with an employee handbook that's, you know, 15, 20 years old. You want to make sure that it's updated more regularly than that. And then you want to make sure that you are applying those policies equally across the board. So we're not going to shut down one employee's cause and advance another employee's cause unless, again, that violates some sort of policy against discrimination, harassment, retaliation. And so you want to make sure it's equal across the board. You're making sure that all employees understand that. One of the common ways that a plaintiff will attack the employer's actions when we proceed to litigation or a similar administrative proceeding is they will say, well, I get that that's the policy, and I get that that's that I didn't follow the policy, but guess what? This person over here who falls outside of the protected category also did not follow the policy, and that rule wasn't applied to them. So you don't always get off the hook by saying, you know what, we followed our policy, because what plaintiffs are really good at is saying, yeah, but you don't always follow your policy. You didn't apply it to this other person over here, and by virtue of that, not applying your policies equally, you've discriminated against me. So you have to be careful with that. And that goes down to kind of that fourth bullet point there. Employers should be cautious if their support for one employee cause over another could be seen as indicative of some discriminatory animus. And again, that's going to be a case-by-case basis. Not necessarily everything that's put out there by an employee is going to be construed as discriminatory, but if your employees are potentially considering it as discriminatory, then you have to follow your same policies about, I need to investigate this, I need to figure out if our policies have been violated, and you want to follow through on that every time there's a complaint on that. There is an important thing for Oklahoma specifically, and I assume that most of you are Oklahoma employers, and if you're not, don't listen to this. But in Oklahoma, political affiliation's not a protected class. In some states it is. It's not under the federal laws, but in some states it is a protected class. Here it is not, but it's still not necessarily something that we want to act upon as far as employment decisions. Oklahoma law does protect individuals from intimidation or the use of force to influence their vote. So you certainly don't want a supervisor in your organization doing something like advocating to try to get employees to vote a specific way, or condemning them for not voting a specific way, because that could be seen as intimidation tactics. Now, there's not a specific law that they can sue under that, but I think that probably the avenue that would occur there is probably a public policy discharge or discrimination case. I haven't seen one of those recently, but it doesn't mean that it certainly couldn't happen. And again, employees are plaintiffs are very creative when it comes to ways of trying to recover. Okay, so we got another question. Are we allowed as an employer to prohibit political speech? How about things posted on social media? So as to the first part of that question, are we allowed as an employer to prohibit political speech? Yes and no. Again, public and private employers are going to be different there. Public employers, there's a lot more restrictions on what they can and cannot prohibit, but I assume that most, if not all of you, belong to private employers. So generally speaking, yes, but again, you want to make sure that you're not running afoul to the NLRA. You want to make sure that you're not prohibiting one person from speaking over another, and only letting one side of the issue discuss. Again, that's going to come up in kind of policies where we say, you know what, this is becoming too tense. All of this political discussion, you're creating problems in the workplace. It's bleeding over into your ability to perform your job duties. We don't want to do that. So mostly the answer would be yes, but there are going to be exceptions. Again, with social media, so it depends. The NLRA has, or the NLRB, I'm sorry, has taken some stances in the past that regulate your ability to prohibit employees to speak out on social media. So again, generally, if it is social media posts that relate to the terms and conditions of their employment, it's certainly not going to be something that you can prohibit under the NLRA. But if you have an employee who is posting things that are blatantly racist or some other protected category that is making other employees uncomfortable, then potentially you could take action on that. So again, it's going to be a case-by-case basis. And if you have a social media policy, you would want to make sure that that complies with the NLRB's interpretation of how those policies are allowed to be put in place. Okay. There we go. Okay, so intersection of traditional employment laws. This goes back to what I was saying earlier about how we have all the tools already. There's nothing new that we need to try to figure out how to treat these issues in the workplace. We already have all of the tools to address those. It's just trying to develop the mindset to realize that we address them under these same things that we're used to doing if an employee makes a complaint of sexual harassment or discrimination or something that happens in the workplace. We know how to address this. We know that we've got somebody that investigates it. We've got somebody that goes and interviews everybody who is involved. We get the employee and witnesses to submit statements if that exists. So we know how to investigate those things, and this is no different. So if you have an employee complaint or if you have an issue that arises, you're going to take those same actions that you normally would in any sense of the problems that you're used to arising in the workplace. So Title VII, everybody knows, it protects employees and applicants from employment discrimination on the basis of race, color, religion, sex, now expanded to sexual orientation, and national origin. So those things should already be in your policies, and you know how to apply that. Now, the tricky thing is when does political speech implicate one of those issues such that you should be concerned about how it's going to work in the workplace. Again, most of the time, hopefully your employees are mature enough to recognize that they should not be engaged in inflammatory political speech in the workplace. But saying how I think people should act and the way that they do act, I think we all know are two different things. So it certainly could come up in the situation. I am hopeful that most of your employees are logical enough to realize that politics have been divisive since the beginning of time, and it's not going to change now. And something that I think a lot of people don't realize, which is mind-boggling to me, is that you're not likely to change someone's mind about how they feel about these situations. In fact, most people tend to dig their heels in and they don't want to back off of their stance, no matter what it is. So you just want to make sure that if it's touching on any of these protected categories, that you're addressing it appropriately. Especially because many of these social justice movements that are very prevalent right now do touch on certain of those aspects. So for example, Black Lives Matter inherently touches on race. It doesn't mean that you should allow all kinds of discussion about it and what happens in the workplace, but it does mean that you should be cautious in how you proceed if you have a complaint that relates to one of these social justice movements that does touch on a protected category. Immigration issues often touch on national origin, because obviously if they've immigrated to this country, then they've probably come from another country of a different national origin than what, they're not from the United States. And then for many people, pro-choice versus pro-life issues implicate their religious beliefs. Not always, but it certainly can. So those are things that you want to be aware of and proceed accordingly if you have any complaints or issues that they come up. You want to make sure that you are not running afoul to Title VII as you address those and as you instruct employees in how to behave. So the next thing is the Age Discrimination and Employment Act. Again, I'm going to bring up the OK Boomer thing, which again, I saw in a number of different comments last night just scrolling through social media. But employers should guard against that, even though it's a popular saying, and even though, a lot of I don't really know how to put this, the younger generations think it's really funny and they comment on it a lot. I mean, I hear it a lot. I have a teenage daughter and I've heard, just going through the high school, you hear people say things like that. But just because it's popular and just because it's common doesn't mean that people over a certain age in your workforce aren't going to take offense to it. And so if we're allowing those types of comments in the workplace, then there's at least a chance, especially if it's being said by a supervisor or some sort, that saying that comment is going to be considered as discrimination against somebody based on their age if those comments are allowed to kind of permeate the workforce. Okay, so I think I must have gotten ahead of myself earlier because now we're talking about, do existing policies apply? Yes. And again, now's a good time to review your employee handbook. Now's a good time to have those discussions with supervisors to make sure that they are aware of what their obligations are and how vital they are, and their operations, their conversations with employees. Everything that supervisors say and do is so important, and it's vital that they know that their actions can help protect the company or they can really hurt the company. So this is a good time to have those conversations with your supervisors to make sure that they're not engaging in that conduct, and that when they hear of somebody else doing it, so an employee makes a complaint to them or they see it happening, that they know what to do. So maybe in your company, the the protocol is supervisor should immediately tell HR, or maybe the protocol is supervisor needs to handle this. You need to make sure that they know what they should do if they receive a complaint or if they witness the conduct. Now, notice what I just said about the second half of that, because I see time and time again, supervisors say, well, I never received a formal complaint on that. There is absolutely nothing in the employment laws that say that you have to receive a formal complaint in order to take action as an employer. And in fact, if an employee did have an issue or eventually filed a lawsuit, they don't look at whether the employee filed a formal complaint that required the employer to act. They look at whether the employer knew or should have known. So was this conduct happening right in front of a supervisor's face and he didn't do anything, or she didn't do anything even though they saw it? Or is this something that they were just completely oblivious to? Obviously, we would prefer the latter if the supervisor knew nothing about what was going on, and so he or she couldn't have fixed it even if they wanted to. But if you end up in a situation where supervisor witnessed the conduct and he or she still didn't take any action, it doesn't necessarily matter that the employee didn't make a complaint. So you want to make sure that you are training your supervisors to know to not only act when they receive a complaint, but when they witness conduct that would otherwise violate your policies. Okay, so what about off-duty conduct? This is something that has been more popular in, I would say, the past few years, where employers are adding off-duty conduct policies to their handbook. Most of the time when you see an off-duty conduct policy, it talks about what to do if an employee gets a criminal charge while they are off duty. So sometimes you see you've got a truck driver who received a DUI on the weekend. Well, that's off-duty conduct. You wouldn't normally consider that to be conduct that you could punish at work, but he engaged in criminal activity, or she, on a weekend when they weren't working, and it doesn't look good for their job, or it could potentially expose the employer to liability if you knew about the DUI and still let this person drive for your company, or whatever the case may be. So it really depends on the specific business and whether or not you want to implement that. And at the end of the day, you don't necessarily have to have a broad and all-encompassing policy about off-duty conduct, but we just have seen a trend where more and more employers are wanting to have that so that employees know what their expectation is for how they behave within the community. This goes to the question that I received a little bit earlier on social media. Many employers do have social media policies, not all of them. I would say probably less than half of the employee handbooks that I've seen have a social media policy in them. We have had several employers who wanted us to add social media policies in there. Most of the time, those social media policies relate to making sure that the employee doesn't advocate on behalf of or as an agent of the company. So you don't want your employees going out and saying, I work for XYZ Corporation and we support this. So you don't want an unintended spokesperson on behalf of your business. And you certainly want to let employees know that, hey, if you put something out there on social media and it is blatantly in violation of an employment law, maybe it's something that is just over the top, blatant racism, and there's absolutely no other way that it could be looked at, or even maybe it could, but many people are interpreting it in a discriminatory manner, then you can be punished for that, potentially, depending on the situation and what the content is. So those are the kind of things that we see employers wanting in those social media policies are, if you're engaging in illegal activity outside of work, or you're posting illegal, if you're posting that you're doing illegal things on social media and we see it, we could potentially take action. Okay, we got another. Okay, so it says if someone sees something on social media that offends them when trolling someone else's page, do we need to take action if it is their political, religious beliefs, etc.? So again, I think this is going to be a case-by-case basis. And just speaking off the top of my head, if you see something that an employee posts something about, they are advocating for a specific Supreme Court justice or something because they're a member of the same religion as them, then that's probably going to be something that is protected. Especially if it's on their social media, especially if it's not brought up in the workplace, or if, that employee could just as easily unfriend that person. But there are going to be situations where you certainly don't need to take action. I would say that it would depend on the severity and the content specifically, and whether or not it otherwise violates your policies. I know that's kind of a non-answer, but I think that really each post would have to be considered in its own right, because I don't think that there's a yes or no answer on this, because it's really going to depend on what it is. And I will tell you that that actually happens a lot, where you see employees, I'm sorry, I got distracted because there's another question. If it is not directed at anyone, would that make a difference? Again, it depends. Who is it directed toward? What is the content? Is it displaying, specific racist messages? Is it, promoting sexual harassment? If it's promoting an idea or a concept that violates your policies, then potentially. But again, if it's just something available to the public, it may or may not be something that you should take action against. If it's something that goes against what you believe as a company, potentially, unless it's indisputably protected. Did I get another one? Okay. Nope. Okay, so if you look at the second bullet point there, you should be cautious because some social media activity can actually be protected. So again, the NLRA says if it touches on the terms and conditions of their employment, then it could be protected. So an example would be employee comparing the Me Too media coverage to his or her own work culture. If they are putting it out there and saying this relates to my work, then it could potentially be protected. I'm not saying it will be 100% of the time, but it certainly could be. And then another example, employee complaining about suspected race discrimination, that could again potentially be protected. That would be if I'm the HR director and I receive a complaint that a coworker has said that they believe they were discriminated against on the basis of race. That's something that I would certainly look into and figure out where those allegations came from, and how to react and make that employee feel comfortable reporting these issues to the company rather than just on social media, because if you're not aware of it, you certainly can't do anything about it. Other than those limited situations where the posts might be protected, private employers are generally free to discipline or terminate employees who violate their policies or who engage in conduct that they disagree with. This kind of goes back to the old saying that employers are free to terminate or discipline employees for any reason or no reason at all, as long as it's not a discriminatory or unlawful reason. So the only issue there is defining what's discriminatory and defining what's unlawful. But otherwise, you are certainly free to take any action that you choose, whether the employee engages in the conduct or says the statement at work or outside of work. Okay, looks like we have 10 minutes left. And just so everybody knows, we are giving away a gift card at the end of this presentation. Can I tell them what it is? Okay, it's going to be a $100 gift card to Southwest Airlines. So, who knows, depending on where you want to go, that could be a round trip ticket somewhere. It may be a one-way ticket somewhere, but either way, whenever we're all ready to travel, you can certainly go somewhere if you win that. Oh, somebody says, wow. That was presumably Stephanie's idea. I think it's a great choice of a giveaway. So $100 Southwest gift card that we will make an announcement for at the end of this presentation. And we only have a few more, actually 2 more slides. So we're almost to the end here. So many employee activism, many employees are choosing to engage in activism such as protests when they're off duty. So this has been something that I think is not necessarily new, because if you look back through the decades, the 70s were certainly a time where there were a lot of protests. And at various times, that has been something that's going on for a lot of different issues, but it certainly is very prevalent right now. The best practice is probably just to allow employees to support the causes that they believe in if they're not otherwise interrupting your work environment, if they're not affecting other employees, if it's not something that's completely unlawful or violating your policies. The only time that really I would recommend an employer become involved in those issues and trying to prevent employees from engaging in those activities that they support would be if it does bleed over into the work environment and it begins creating problems. And again, that's going to be approached on a case-by-case basis to determine whether or not the conduct that they are doing or want to do is protected, because that's the primary determination. If it's protected, we can't do anything about it. If it's not protected, you certainly can. So we're going to make that determination every time before we act and before we decide what to do and how to treat an employee. Well, this is pretty repetitive. I don't know why I did this twice, but employees' repercussions for off-duty conduct. As a general rule, at-will employees can be disciplined or terminated for actions taken and statements made when they're off-duty or on duty. But before taking that action, just make sure that you are considering whether or not it's protected, whether or not it exposes you to liability. You might also look at who said it, who did it, when. And, you know, the question that I received earlier, what if somebody's just trolling their social media? Those are certainly going to be good data points for determining whether or not you should take action or whether or not the issue is severe. Because if an employee has to go out of their way to find the offending conduct, then it's probably not necessarily as offending as it would be if it was, if the employee didn't do anything to come to the issue and it was just put in front of them. But again, we're going to make sure that we're evaluating it every time, no matter what. Okay, so now you're going to see my contact information here. If you have any specific questions that I didn't address today, I haven't gotten any more. Oh, I've done something. Okay. Okay, so I don't see any more questions. This is my contact information. If you have any specific questions, I'm happy to walk through those with you. And I can be contacted at the number there or via email. I'm happy to help with any of those issues that might come up. Looks like we may have just gotten one more question. Huh? It doesn't, it's not cut off. Oh, okay, sorry. On this last screen here, there is an @ after McDuffie, melissa.mcduffie@crowdunlevy.com. So I have right here the information of who's won the Southwest gift card. I know you guys are all just, you know, definitely waiting for this. And I will tell you that I do not get a Southwest gift card for giving this presentation. So I'm calling an unfairness point on that. But okay, so congratulations, Jeff Faust. We will contact you, and by we, I do not mean me, I definitely mean Stephanie. We will contact you this afternoon regarding your gift card. We should already have your contact information because you registered for this seminar. So thank you all for coming today and for enjoying the presentation. And again, these slides and everything will go out to you tomorrow, and reach out if you have any questions. Thank you, everyone.